Good morning, everyone. So today we are going to explore the classic questions in company law. If something, if something goes wrong in a company, who has the right to sue? To answer this question, we are going to travel back to 1843. We are going to see the foundation and set a case, which is Force against Harbottle. So how about we watch it unfold? Guys, look at this. This is outrageous. Director purchased a land at the double of the market value.
Look, Mouse, let's calm down. Are you sure? Even if you're right, doesn't mean you have the authority to sue. We're just shareholders. Doesn't mean that we own the company. They own the company. They're the boards.
But however, we own part of this company. If the director is mismanaging it, we must act.
Look, Foss, you're just wasting your time. Just let it go.
Now, I'm filing a lawsuit. And so, Mr. Foss did file a lawsuit. What happened next changed the company law forever.
Let it be known that today we are present at the final hearing of the case of Mr. Foss against Mr. Harbottle. Mr. Foss, you have brought a claim alleging that the company assets were misused, but you sue not on behalf of the company, but personally. Yes, Your Honor, I'm a shareholder. I have my right. You misunderstand the issue, Mr. Foss. Based on all of the available evidence and the facts of the case, I find that the company is a separate legal person. If it has been wrong, it must sue its own name.
Oh my god, I told you so, Foss.
This is the proper plaintiff rule. Shareholders cannot sue for wrongs against the company. The company must take legal action except, however, there is a concern where our legal system prefer internal remedies before judicial intervention. So, the majority can let the director get away with it? Not always. There are exceptions to this rule, but unless one of those applies, the majority rule stands. This court cannot allow minority shareholders to interfere every time they disagree. Otherwise, companies would be paralyzed by litigation.
Two key principles emerge. First, company is the proper plaintiff. Second, majority rules even the minority. But that's not the end of the story. What if the majority is abusing their power? The next few scenes will explain 4 exceptions regarding these rulings. Mind you that the scenes will not relate with the current case.
Hey guys, did you guys hear that the director is using the company funds into investing in the luxury resort in France?
That is ridiculous. We are a park management and development company. That is outside of our company objective club.
But I also heard the director just expanding to hospitality.
But that can be done without the shareholder approval. That's ultra vires.
Ultra-virus. Ultra-virus refer to an act done beyond the legal power or authority of the company, as set out in its constitutions.
When a company acts beyond its power, defined in its constitution, so it is ultra vires, so shareholders may challenge it.
Guys, the board decided that we are merging with Hampton Park Company and it's effective immediately.
What? That's need a special resolution and a majority of 75% at general meeting.
Technically can be bypassed because we have enough influence.
No, I demand this merger to be halted until proper vote is held.
The law is clear. Bypassing due process violates core governance principles. The court will uphold the rights of shareholders when rules are ignored.
What is this? I didn't receive a notice for an annual general meeting. I didn't receive a voting right for months.
Must be an administrative oversight.
No, it's deliberate. They've done this before.
But these are minor issues.
Shareholders have individual rights. The right to vote is fundamental. If you strip that, you strip the very essence of ownership. If infringed, they can sue.
Let's issue 1 million new shares. They are priced low, so we only can buy. This way, Force and the others will lose influence.
Hey, you intentionally diluting our power for your personal gain.
This is a clear betrayal of trust, guys. Can you guys see this?
What are you thinking? It is legal. We hold the majority.
When the majority use power to commit fraud on the minority or expropriate value, courts can intervene. This is an exception to the rule in force against Harbottle. A shareholder can sue because they are unhappy. A company must sue.
The majority usually rules.
But even directors have limit.
Courts protect the integrity of corporate governance.
My personal rights matter.
Being in control doesn't mean I can exploit others.
And that, class, is the legacy of Force against Harbottle, a tale of power, limits, and justice in the world of corporations.
God!